Oh, ma'am, we are good to go.
Okay, just a second. So we'll start.
Yes, ma'am.
A very good evening to everyone. I, Shivangi Sinha, Assistant Professor, New Law College, Bharatiya Vidyapeeth, Deemed to be University, Pune, and Faculty Coordinator of Madhyasthata, the ADR cell, welcome you all to today's session of Prudentia Amicus. Bharatiya Vidyapeeth was established by Honorable Dr. Patangrauji Kadam. He was a renowned educationist, leader of the masses, essence of the excellence, a man who has changed the lives of millions through quality education, a pioneer in the field of social transformation. The university is now led under the guidance of Honorable Dr. Shivaji Rao Kadam, who is the Chancellor of our university. Sir has recognized the importance of education at very early stage. Under his guidance, our university has received numerous accolades on its name. The other distinguished luminary in our administration is Honorable Dr. Vishwajit Kadam, who is the Secretary and Pro-Vice Chancellor of our university and also the Minister of Social Justice and Special Assistant Department in the state of Maharashtra. Under his dynamic and visionary leadership, the institute established itself as one of the highly acclaimed centers in India for advanced studies and research in science. Lastly, I would also like to mention about our principal in charge of Bharatiya Vidyapeeth deemed to be University, New Law College, Pune, Dr. Bhagyashree Deshpande ma'am, under whose guidance our college has gained a lot of popularity among the masses. Madhyasita, the ADR cell, is a student-driven cell established by New Law College, Bharatiya Vidyapeeth deemed to be University, Pune, a year ago. Since its inception, the cell is working throughout in the field of ADR by the virtue of conducting events, seminars, etc. Prudentia Amicus is one such instance by the cell to assist students in enhancing knowledge and understanding career prospects in the field of ADR in association with esteemed dignitaries. It aims to give students and all the ADR enthusiasts a wide scope and a better picture to make their future decisions in the field of ADR. Dear attendees, today we have among us Ganesh Chandra Kabi sir, who is former chief engineer and arbitrator at Government of India. Sir has a wealth of experience in construction and infrastructure arbitration. Also, Sir has made around 175 arbitration awards as a sole arbitrator, out of which 95% were accepted by the parties without any challenges. Sir is governing council member of Society of Construction Law, India. Following this, Sir is also a fellow Indian Institution of Technical Arbitrators and former senior vice president East and fellow Institution of Engineers and Chartered Engineer India and life member India Building Congress. Sir has published various articles in the field of arbitration and law and has also conducted various conferences and workshops for the same. We are grateful to have Mr. Ganesh Chandra sir with us to guide all the ADR enthusiasts for our today's session on construction arbitration and its career perspective. We welcome you, sir. Now, I request sir to kindly initiate the session. Sir, please.
Thank you, Professor Sinha. My privilege to join today with all of you. And I wish you a very, very happy new year, all of you. Best wishes to New Law College and Bharati Vidyapeeth and the Madhyasthata. I also wish all the best. I am told many professionals are also have registered and they are online. So my best wishes and for a very good new year to all of you.
Thank you, sir.
Now, I would presume and not cover the general aspects of arbitration and the contract law because let us talk about the construction law. I'll try to summarize some of the things which I, as a practitioner, have understood this. Coming from basically an engineering background and shifting to law later on, I will have my own perspective on this. The construction law arbitration is primarily something which deals with construction law. It is a specialized arbitration within other type of arbitrations. Of course, there are so many things which are common, obviously, but so far the substantive law is concerned, construction law has developed as a legal specialty. So that is one important part of construction arbitration, which deals with construction law. The second part is the procedure. So the procedure in construction arbitration is also something to cater with this construction law subject and the peculiarity of construction contracts. So let us see what is different in construction contracts compared to other contracts. The construction contracts are primarily document heavy and consist of complex facts as well as technicalities. And this sets it apart from other contracts. The typical thing that happens in construction contracts is that there will be thousands of documents, and that constitutes the factual matrix. And the law which is to be applied in the factual matrix, that makes the difference in construction law. As it has been told, the construction law is primarily a journey of recognition by the judiciary of textual contract, from moving from text to the context. And that is the typical thing. Every contract is different and its facts are different. And if I recollect, there are at least two judgments of Supreme Court in McDermott International 2006, and subsequently that was by Justice S.B. Sinha and then Justice Nariman in Associate Builders. They have recognized that the conduct of the parties and the correspondence shall also be taken into consideration or interpretation or construction of the contracts. And that makes the fundamental difference with respect to the other contracts, because the construction contracts are carried over a long period of time. And many times the parties might not follow the strict provisions of the contract. And then the interpretative issues come in tribunals, and that makes the different contexts are to be seen for interpretation or construction of the contracts. That is the difference. But at the same time, my own understanding is that over a period of time, as a reaction to the contextual interpretation of construction contracts, the drafter of construction contracts, the standard forms of contracts, they have made these contract documents more and more elaborate, almost trying to take care of every contingency and to fill in the gaps, to avoid contextual interpretations. But still, the situations vary so much that that cannot be avoided. So what we say, the implied obligations or interpretations that still happen in construction contracts, and we may write sometimes to one thing we can do, many contracts, what they do, they write that it is an entire contract. Once you write an entire contract, you are primarily trying to say that whatever happened in the background before entering into the contract, what is not in the written contract, or the background correspondence will not be part of the contract. So this is the entire contract. But then still the subsequent happenings come into picture. I will just give an example, like if we do a contract for a private home or a 100-story building or a remote hill road, the same terms or the obligations may not be taken into same interpretations. Like suppose a issue comes of duty of mitigation. Now, the duty of mitigation will vary whether it is regarding the labor force, it is regarding skilled staff, it is regarding a heavy machinery, and whether it is in a city or it is in a remote hill road. So we can't apply the law exactly in the same way. That is the peculiarity of construction law. And that is why we need people who are trained in construction law to deal with either as a counsel or as an arbitrator. So this is one of the things which is it differs from others. Second thing which is important is the different standard forms of contracts. And for those who have not gone or have practiced arbitration or construction contracts, we have different type of contracts like item rate, percentage rate, design and build, EPC, engineer, procurement and construction, and then now PPP and some other modes of contracts. Now the implied obligations under these contracts are different. In an item rate or percentage rate contract are known as remeasurement contracts. So anything which is not in the schedule or bills of quantities, that can be measured and will be paid as per actuals. So what constitutes variation in an item rate or percentage rate contract is not a variation in an EPC because there is no bill of quantities there. Because the definition of variation in an EPC contract or even in a design build contract, which is based on lump sum, is something if something is ordered beyond the scope of the work. But there can be a variation within the scope of work in item rate contract. So that makes a fundamental difference in interpretation. There are disputes whether it constitutes a variation or not, and in major contracts, and the amounts involved are huge. So again, the types of contract becomes very, very important. Now, considering various obligations. Now, as you know, suppose the employer hires a designer or employer hires a designer, like in item rate or percentage contracts, which are engineered by the employer, then the designer or the planner has a basically, or architect, whoever it is, has a obligation of normal ordinary duty of care, basically. And the standard of care will be governed by whether he was negligent or not, and the codal provisions are met or not, like that. But in design build or in EPC contract, the obligation is of fit for purpose, and which is beyond negligence. So now one has to very carefully see the type of contracts which are chosen. And probably in India, the situation is more complex because in almost every organization has its own standard form of contracts. And then there are bespoke conditions where they have modified these conditions. So even application of case laws become very, very difficult. So what makes a judicial precedent in an interpretation of construction of a contract is more complex when there are such conditions and certain provisions are different. So in some other countries where case laws have developed, like in England, mostly JCT and NEC forms of contracts are there. So it can be more certainty of the law, but in India, it is that way more difficult. So one has to also look into the type of contracts uh, which are being adopted. Now, what are other important thing is that, like in these contract documents, there are so many other references and documents which are taken within the contract by incorporation by reference, like schedules by specifications, and so many corrections beyond the standard form. And in fact, in one of the judgments, the Honorable Supreme Court held, I think M.K. Abram versus State of Kerala, that it is a nightmare to understand a public works contract. So the question is that how do we interpret? There will be inconsistencies in the contract. Then those are also part of construction law, and certain principles and authorities have developed around that. Now, construction contracts have certain typical terminologies and phrases which are understood here in a way which the general law of contract might not have an elaborate arrangement. Like there is a partial breach or total breach. Now, the rights that arise out of partial breach in a contract, out of a contractual provision or in the law is different when something we call is a total breach. Now, that is typical to construction contract where these things are considered. Similarly, there is something called substantial or practical or virtual completion. Now, this has important ramification because the defect liability or maintenance period will start from that. The performance bank guarantee may be released on that date. So whether and when a work has been substantially completed, the contract may have a provision of completion, total completion, but maybe it is taken over or put to use on substantial completion. So there are disputes whether it is substantially completed or not. Similarly, there are contracts where there may not be a provision of any phased or sectional completion and taking over, yet it may be done. Then how to apply the LD clause for delay where it does not have a provision for sectional taking over. So these are issues which come into account here. There are some typical concepts like economic waste, uh, and which is linked to substantial completion. These also do come into construction law issues. Suppose there is a swimming pool which was to be constructed, which had a suppose 15 feet depth. It was done suppose 14 feet. And so it was not done as per the contract. After construction, what is the remedy? Should it be normal principle like the cost of repair? Now, repairing it by demolishing it will be too expensive. So other option is that it is being taken as a substantially completed. It can be put to use, but there can be some reduction in its value and the payments. So these things are typical to construction contracts, and these are used in the context of each and every case. There is no proper in a guideline for every case how it is to be used, but this is how it is to be done. Now, in another very complex issue comes regarding extension of time clauses, what is known as EOT. And the extension of time related issues are probably the single most complex issues in construction contracts, and which more often than not come into arbitration and create and these pose great difficulties because there are issues of disruption and there are issues of delay, and these are two different things. And disruption may cause delay or it may not cause delay because there is something called a critical path. Whether the critical path activities are affected, that it will cause delay, and even if it doesn't affect the critical path, there may be disruption and loss. Now, so disruption deals with something called loss of productivity, and delay claims are primarily based on other fixed and other expenses which cause loss, and where contract is performed beyond the original stipulated period. So how these assessments are done, the principles applied, these vary. And for your information, some of you, that Society of Construction Law, there it has published a delay and disruption protocol, and that has been updated. Original was in 2002, now in 2017, which deals with these issues and analysis of delay and record keeping, about documentation, how to avoid disputes. Now, one term is used in construction disputes, that is called concurrent delay. And the concurrent delay is also defined, whether it is a true concurrency or effective concurrency. Now, the effective concurrency is something which deals with not when the delay event occurs, but when the effect of the delay event is felt. And true concurrency means these totally they overlap each other, start and finish data sim, which is really normally doesn't happen. There cannot be true concurrency. Then there is a concept of dominant delay and apportionment delay, and something called potency of delay. Now, these issues just do affect the delay analysis and the claims in construction arbitration. So, which are typical to construction contracts. Now, another issue which is more complex than delay analysis is the quantum analysis. And nowadays, mostly experts are engaged for delay analysis and quantum analysis, but still for delay analysis part particularly, there has been some reaction in some jurisdictions by the courts because we can't do away with the common sense approach by getting into sophisticated systems or softwares getting into absurd results. So probably we have to also take care of that. And now as a lawyer, or you need a much more collaborative approach when dealing with construction arbitration. Maybe you need professionals from various fields, but still you need familiarity with what others are doing, like experts or industry experts or the technical experts. So this is what is one of the requirement of it is a multidisciplinary approach which is required. because it may not be possible to develop expertise on all the fields of construction arbitration and need a collaborative approach, but still one need to be familiar with it so that one can appreciate these issues well. Now, one thing I will touch upon damages, and which is again a claim of there are two types of claims normally will happen, and one is of technical or purely contractual claims involving technical interpretations of specifications, schedules, and other things which are primarily based on the technicalities and technical problems. There are problems like within technical problems like defects and rectifications and all these things. So one need also to find out the root cause of the defect. Who is responsible? Is it a design problem? Is it a workmanship problem? So this is one part of it. Another is that damages claims, which are based on, again, on a factual matrix, but still the law is to be applied on that. And we cannot put the whole categories of damages under the same brush. So Contract Act may be dealing with under Section 54 or 73 or 74, but here the different damages will have different types of burden of proof. And I give an example that in an extended period, if you are claiming for price rise and you are relying on legal principles, even if the contract does not have a provision for price rise, there are judgments like PM Paul and Sector Palan where it can be permissible when the delay is attributable to the other party. Then how do we assess the delay? The burden of proof will be different from a risk and cost claim, where you have to actually show the what was the risk and cost based on different judgments, which lay down the principle, because where you can prove the loss, you have to show, you have to prove it. But I can't prove this type of price rise claims exactly because I did not do that work exactly, and there are hundreds of items. It is not possible. Then probably the indices are considered as a good indicator, and these are acceptable. But same may not be possible when I am claiming an on-site claims. So when on-site claims are there, then actual evidence and data may be required. So the proof requirement of proof and evidence is different. Now, when I'm claiming from head office overheads, formula can be used, of course, with some authentic data about the turnover and overheads of the head office. But these are permissible. What is happening many times, these judgments and case laws which are relied upon by both the parties are, I find, somehow misplaced to some extent when the burden of proof requirement is put in one type of damages for the other type of claims. Similarly, like there are loss of profit claims, and if the work is exactly actually done, executed, then whether loss of profit claims are admissible and to what extent uh, and admissible or not, that itself becomes an issue. Normally, a contract is terminated or descoped, loss of profit is claimed. Otherwise, loss of business opportunity it requires a high degree of evidence. Now, one more problem which comes in such contracts, like it is not the case of the second limb of Section 73 of Indian Contract Act, where it deals with indirect losses or consequential damages. What category of damages are consequential damages, or that itself becomes the main issue in construction contracts, which are direct and which are indirect. And because, of course, we know that for consequential damages, the knowledge at the time of entering into the contract is necessary. But then the dispute becomes on a different ground. Now, if I come to the procedure part of it, some of it, now I will give a reference of, I think, ICC Commission report, and that is Construction Industry Arbitration 2001 and now updated 2019. It recommends tools and techniques for effective management of construction arbitration. Now, that is available in Google also. So it has been recognized by ICC that construction arbitration requires a different type of procedures. And some of the important things are there, was into my understanding, as you know, under Section 19 of the Arbitration Conciliation 1996, and probably unsettled model law, similar provisions in other jurisdictions also. And the parties can agree for a procedure, and then otherwise tribunal can decide a procedure. But most important thing is that The admissibility, relevance, materiality, and weight of evidence is to be decided by the arbitrator. Now, once in a document heavy pleadings, uh, the real issues which are there, that requires in some cases framing of issues. And there, one of the important requirement is that how do you take out the important issues and streamline the arbitration, which requires skill by the counsels as well as the arbitrator, because what we find is that most of the pleadings, they contain many relevant as well as not so relevant issues, so which are actually relevant and material. That is one important, and one of the skills that is required is that out of thousands and thousands of documents to find out what are really material documents. So this is one part of it. Second issue comes about the discovery or document productions, and now that is also becomes takes long time, and then how to control and streamline this. And the fact witnesses, of course, probably these are being used, but in most of the engineering contracts, it is found that the documents are contemporaneous documents are a better source of evidence than fact witnesses. And though fact witnesses are produced and cross-examine other things, and these need to be controlled, otherwise the arbitration proceedings become too lengthy, and maybe sometimes not may not be very relevant, but these do take place. But these are, in particular in India, these are required to be much better controlled by the tribunals with the time, like it is done in international arbitrations. Now, another thing is that party experts and tribunal experts. Now, the tribunal itself may not have expertise sometimes, or the issues involved may be so technical that industry experts may be required. Now, though Section 26 of the Act or the even unsettled model law does not speak about directly about party experts, which can come later, but maybe the effect of common law adversarial impact is that since a party has a right to present its case, now normally parties bring experts. So controlling these also become important. And these three aspects, as you know now, the Prague rules has come as a reaction to the IBA rules of evidence are also sufficient, but and good enough, but then the way these are operated, the reaction has happened to that. But in construction arbitration, one important thing in mostly happen in complex international arbitration is something called splitting or bifurcation, where liability and quantum can be bifurcated and the evidentiary proceedings can be separated. But that requires a lot of skill, because if something is uh, touched or decided in which is have an impact on the later on, then that has to be considered. That may have that may prejudice to somehow. So these are the probably some of the important things in construction arbitration. I will only tell one thing to be taken note of is that probably the case laws will be very relevant, because since the Contract Act, Indian Contract Act 1872 is not very exhaustive. It's not a consolidating act and doesn't contain the whole law of contract. So the case laws are very relevant for construction arbitration at least. And if you look into the statutory developments, then there are different statutory developments in different jurisdictions. So in the international commercial arbitration, if the substantive law is of different country, and if you see in England, there are different laws like Unfair Contract Terms Act 1977, Third Party Rights Act 1999, which are not there in India. And so some of the statutes like SGCRA has given some rights now regarding suspension of work in case of non-payment, which is not existing in India. Whether under Contract Act, under Section 51, that can be operated is just something to be seen. So the substantive law makes a difference, and that is how the case laws are very relevant. And I think to have the question answer session, I will end it here. Thank you.
Thank you so much, sir, for such an insightful session. Now we'll move ahead with our next session, that is our question answer round, for which I would like to request Sajal, one of our student of Bharatiya Vidyapeeth deemed to be university, and a student member of our cell to kindly initiate with the session. Sajal, please.
Thank you, ma'am, for giving me such an opportunity. Good evening, sir. So let's initiate the Q&A session with our very first question, which is raised by Ashruti. What are the laws and procedures involved in a construction arbitration?
Good evening, Sajal. Thank you. Uh, the construction arbitration involves particularly the law of contract and what I talked earlier, construction law, but along with it, it will develop, it also involve other laws like law of limitation and some of the laws for which will be particular facts will be concerned. But so, as you know, in international construction arbitration, the procedural law will be the law of the seat of arbitration. So obviously, if it is India-seated arbitration, then Arbitration and Conciliation Act 1996 apply. In other countries, though there is, as I told, a lot of uniformity or based on the laws in various jurisdictions as per the New York unsettled model law. So we may see in various common law jurisdictions similar law, and so procedural law will be of the seat of arbitration. And in international commercial arbitration, as you know, these are of course subject of academics, that the arbitration agreement has a law, the seat of arbitration has the procedural law, and the substantive issues will have the governing law of the country. A governing law is chosen by the parties as applicable to the disputes. So as I told, in construction arbitration, basically the construction law will apply. And what is the construction law? Primarily, one has to be seen based on, because we don't have a codified construction law in most jurisdictions, and neither in India. So that we have to find out. I think we have to, as I'm talking about the contextual contracts, and of course, the Indian Contract Act will apply in India, and similarly, there are statutes in other countries; those will apply. But beyond that, and there is a vast area where the construction law will apply, and the construction law does not apply, is not this exactly the same in different jurisdictions. Right? For example, if you take a FEDIC contract which has a notice requirement as a condition precedent to make a claim, and there may be a conflict between the prevention principle and their notice requirements. Now, whether notice requirement is mandatory in some of the Australian courts, it has been held not to be mandatory and is a directory. Whether in England, it has been now considered as mandatory. So the question is that the law, then again, we have to see in under which jurisdiction substantive law we are applying. And if you see like section 28, subsection B of the Indian Contract Act, which also puts a bar on extinguishing the rights, and that is a substantive law, but that may not be there in some other jurisdictions. So where the rights can be barred, though the limitation will apply for commencement of arbitration, fine. So the question is that one has to see these things. Now maybe there in arbitration we are now section 17 has been amended, and injunctive powers are also there for the tribunals. So then again we have to see this, the maybe the principles for CPC, and though CPC does not apply in arbitration, but those principles will apply. Similarly, the specific relief act has been amended. So I think in arbitration, even in construction arbitration, the laws will apply depending on what are the issues involved. There are issues involved with regarding various labor regulations also. So, and these are part of construction contracts. And there may be, of course, the general law of contract will definitely apply, and with case laws. That is what I think we have to see, what are the issues involved.
Thank you, sir, for such an insightful answer. The next question is from Urja. What, according to you, should be an ideal approach or path that students should follow in order to pursue a successful career in the field of construction arbitration?
Uh, my advice will be that as students, one should first focus on the theoretical and conceptual issues, and probably we should have a very good grounding and very sound understanding of the law of contract. And I think what happens probably as we are looking into construction law, that will can be seen. But I will tell you the basic uh, law of contract, the understanding of various principles, those will definitely come in handy later on. So as a students, because the construction law is not per se, I find, as a syllabus in any of the law colleges or engineering colleges anywhere in India particularly, this is being done as a specialization in other countries. But if before we get into the construction law, first we should have a very clear understanding of the uh, law of contract, because what I understand in the time the students get in colleges and over few semesters and so many subjects, uh, before getting into any specialization, one should have a good understanding of the general law on all the subjects, on all the parts of it. And after that, subsequently, if you want to pursue construction arbitration, which again, I think as a lawyer or an advocate, one should initial years to try to get into different fields of the law and not start specializing at the very beginning after passing a law. So specialization should start after a few years. But then after that, one has to have other parts of the subject. As I was telling, one must have good authority about various standard forms of contracts and their interpretation and the case laws. That and of course, one has to have the knowledge of the Arbitration Act and other things. So that goes without saying, because part of the practice will be in court and part in tribunal. But as I see in future, the court practice will diminish and tribunal practice will increase in arbitration, because even Section 11 is very shortly to move out of the courts. So it is the institutions will appoint an arbitrator. So it will be under some of the provisions where in practice arbitration in the court, that is under Section 8 for reference or Section 9 for some injunctive measures, or 14, 15 for substitute arbitrator, 29A for seeking time, and mostly Section 34 for which also the scope has been getting reduced. One more area will be enforcement of foreign hours, and that will be there, or enforcement even for domestic hours. So question is that for tribunal practice, one has to have good command over the construction law and the standard contract forms, in addition to what is base knowledge about the other things are required. So one has to get into that, and probably you should also invest on good networking, and that is very, very important.
Thank you, sir, for such an elaborated answer. The next question is raised by Harsh. If the contractual timeline for giving notices is not followed, what are the repercussions for the claims?
Yeah, that is what I was referring. Whether a notice is a condition precedent to make a claim or not is important to find out, and that is a matter of interpretation or construction. And it also depends on the jurisdiction in which you are, the law, substantive law you are applying of which jurisdiction. In some jurisdiction, in some contracts, these are being treated as condition precedent. And I will tell you with one additional reference is that in 2017, FIDIC has amended its contract standard forms. And as per that, there is a timeline within which you have to make two things. You have to give a claim, and you have to give contractual and or other legal basis of the claim. And if you have not give the contractual and or other legal basis of the claim, I am not talking about, see, for presently many cases when projects is handled, lawyers are not involved. Now this brings back even lawyers into project management and handling contracts, because how an engineer normally in a project will make a claim with a legal basis of the claim. So, and that is a timeline. And if you don't give that timeline as per these FIDIC contracts, then your claim is barred. Now, in India, one issue is that which is being raised regularly, and there are dozen of judgments in Delhi High Court in other cases. Section 28B, as under for that, your right cannot be extinguished before the limitation period. So there will be some conflict with such clauses, while applying in India. Because of the provision of the Indian Contract Act. Now, of course, there are some views on this also. Some say there is a difference between the procedure to be followed and this is a procedural matter and must be followed to have a claim. So that is something debatable, but mostly in Indian courts, to my understanding, the notice requirement has been considered in most cases as prescriptive or directory and not mandatory. And if you go by interpretation, they will tell, okay, suppose a party which is causing the delay, suppose an employer has not issued a drawing, he is very much aware of it. And you are giving notice of that, you have not issued the drawing. So there may be an argument, okay, if you tell that, then there is a concept of early warning system, then I would mitigate, I will minimize it. So requirement, what is the purpose of notice is only have a knowledge. If you see, look in that purposive interpretation. So these things will come. My personal view is that we cannot take is a condition precedent and barring claims easily, normally, unless it is so evident that the contract is worded in such a way that it is a must provision and it treated as a condition precedent. Otherwise, the claims should be decided on merit. It cannot be barred. But in many other jurisdictions, particularly in England, they treat it as a condition precedent.
Thank you, sir, for the insights. The next question is asked by Soumya. What are the requirements for the construction contract to be formed?
Construction contracts to be formed. See, construction, you see how the construction contracts are framed. If you tell the process of construction contracts, finally an employer, he wants a work to be done. It may be a building or a bridge and something. If you want to know the process, because that is what probably for 2 decades of my career I was involved in. There is a process for how estimates are framed, drawings are done. Then a particular standard form of contract is made, schedules are prepared. Either these can be outsourced or these can be done. As I told, different type of contracts, these forms can be adopted. And then obviously you don't start writing a contract form every time you do. You adopt some standard form of contract. You put your special conditions or some things, and that is how you make the contract. You form a contract. What are the essentials of contracts? Of course, Indian Contract Act says section 10, but how a contract is formed is basically you have a what you call invitation to treat. Basically, you invite tender and contractor puts a tender and you look into its justifications and everything. And there is a process in most government departments that is called administrative sanction. If it is you are dealing with government contracts, there is one administrative approval, another is technical sanction. An administrative approval is an authority of the competent authority that this work is to be done. A technical sanction is a sanction where some technical person says that whatever has been done is technically sound. Now, this issue was debated when I was chief engineer in Central PWD. I dealt with it in an EPC contract, how an officer, when it is engineered by the contractor, how and why an officer of the department will give a technical sanction. Then the question arose whether in a government work, the technical suitability of a work can be outsourced to a private person. So that has referred to the ministry. I don't know. I had left the department, but this was the question. But the processes are like this. And then, of course, you award and work and issue LOA and then contract is formed.
Thank you, sir, for answering this. The next question is raised by Tanmay Tripathi. What are the advantages of choosing arbitration for resolving a construction dispute?
Let us look into the alternative. See, there are 2 things. Of course, arbitration is an alternative to the court. Okay, and the only question is that why these disputes cannot be decided in court. And if you see other areas, whether it is negotiation, mediation, and conciliation, okay, all these are good, but these have not been found very successful in India because other party is a government or PSU, and actually really it is not taking place. Very less scope of doing that as on today. So something to be final and binding, unless it is a court decision, the only alternative probably is the arbitration. So what I am trying to now compare between why not to do in a court and why you do in arbitration. If I remember correctly, before the around 1996 Amendment Arbitration Act, I think there was a meeting called by the then Prime Minister Sri Narasimha Rao, and a convention had taken place with the Chief Justice of India and with the High Court judges, and where a resolution has been passed that all most commercial disputes should be decided by arbitration. Because the purpose, the reason was that the courts are clogged, and so arbitration is the best way. That is an administrative reason why you want arbitration. But then, if you look into the advantage of arbitration, is that in arbitration, still parties have some control. Parties have a control how to present your case. Parties have a control in choosing arbitrators, which you don't have in a court. Parties have a control in choosing what type of arbitrator you want. Want a legal person, or you want a technical person, or you want a combination in a three-member tribunals. Those are not there. Third thing is that continuity. In an arbitration which are fact intensive and complex, if you would change the composition of the tribunal, or suppose it goes to court over 1 year or so, it will be extremely difficult. And courts really do not have the time to get into fact finding. Now we don't have the jury system anymore. And so the question is that if these are factually complex, since these are factually complex, tribunal are the best. I'm not telling that every construction arbitration is happening in the best way, a professional way it is happening, but that is a different issue to be addressed. But arbitration obviously has the advantages of flexibility, expertise, and if I go into internationally, of course, there is no other option, because whether it is neutrality issue or the enforceability issue, then arbitration is a requirement. Because in both cases, the way an arbitration award will be enforced in any other jurisdiction by virtue of New York Convention, a court order decision will not be. So the mechanism of enforcement is one of the biggest advantages in international commercial arbitration, to choose arbitration. But otherwise, it is basically the flexibility, time, and probably I can't say cost, though it is obviously told in every book, it will be written the arbitration is cost effective. It may not be so, because the cost may be in courts may be cheaper than this also. But question is of time, and doing a focused and continuous thing in, and the expertise and the flexibility of the counsels, because you can take help of people, even a lawyer and an engineer together can present a case in an arbitration, which is not possible in a court. It doesn't happen. So it has its own advantages, and arbitrator can be inquisitorial. It may not get into the whole adversarial process the way court follows, lack of formalities. So a lot of advantages are there.
Thank you so much, sir, for explaining this well. The next question is raised by Satakshi Dikshit. How does a person become a construction arbitrator?
So far, probably the scenario is not same in India and abroad. And in India, you become arbitrator when you retire from your service, generally. So that is how it is happening. Not the best way to happen, but that is the reality. So it is in India, the arbitrators are retired judges and the retired engineers. And young arbitrators are comparatively less in number here, which is probably happening in other jurisdictions. Now, arbitration as a career, as an arbitrator, career, to choose as a career. Now, if you are an advocate, probably as a person, if you are not an engineer, so if you look into your career, probably the first thing is you have to practice as a counsel, construction arbitration. And then once, of course, I say the skill set required for a counsel and arbitrator are not the same. These are different. But when you work as a counsel, you obviously can develop yourself as an arbitrator. The question comes after a few years, is that not that you are not cannot do arbitration, but who will appoint you as an arbitrator? So today, if I look into the Indian scenario, if the Arbitration Council of India comes really, and what regulations they frame, and how arbitrators are empaneled, so a lot will depend on that. I personally feel that students, not students, the practitioners in their 30s and early 40s must come as an arbitrator, as a career. Probably it is not that people may not be willing, but it is the system must allow it. So that when you are in late 50s or 60s, you are in a different league. In the I do not know how many international arbitrators are from India. Really, so that cannot come if I take into arbitration and at a post-retirement age. And there is a misnomer that anybody post-retirement is a judge or an engineer is an arbitrator without training. Because if you say that we want to train our top professionals and the retired judges and arbitrator, it may not be probably acceptable something, but that is what is required. Because arbitration is different from court proceedings. So question is that problem can be resolved if we take people. But I am hopeful that if ACI comes and this issue is pursued, then maybe in 30s and 40s, those who are practicing construction arbitration can become construction arbitrators.
Thank you so much, sir, for your views. Moving on with the last question of the day. What does the future hold for the construction arbitration in India and globally? This is asked by Ansh.
Hi, Ansh. I think I did not name all the questionnaires. Anyway, this is a good question. And to me, I understand there are two parts of it. One thing is the volume of work, whether there is a work or not. And second thing is the quality of it. And so far India is concerned, and the volume of domestic construction arbitration has increased tremendously in the last few years, and it will increase further. And the quality is evolving. We are nowhere near professional arbitration, the way arbitration is conducted internationally, due to various reasons. Because we don't have very many arbitration lawyers and counsels in India, construction arbitration counsels, because there are court practitioners, plus tribunal practitioners. We don't have trained many arbitrators, construction arbitrators in India. And the procedures and the way these are conducted are not at par with what is done in internationally. But as I see in the Indian arbitration, if you see the act, it is more like a backwater of international unsettled model law. So it is probably the domestic arbitration is coming from the international commercial arbitration. It is how it looks like here. So we are also adopting gradually the good practices which are in arbitration, which are being followed internationally, because that is some of the institutions which are now evolving here. They're trying to put it. The international institutions also have centers here. One more unrelated thing I will suggest, that if you are doing arbitration, you should be also conversant with these various rules of various arbitral institutions. So that is how it is happening. If institutional arbitration will grow in India. Right now, Indian in arbitration is mostly ad hoc. And their effort is to convert into institutional arbitrations, but institutional arbitration has not developed in India. And I think institutions themselves are to be blamed for this, because unless they convert into full meritocratic and institutional mechanisms based on merits, it will not have there is a trust deficit between the customers and the institutions today. And that has to be bridged, which is to be fully not based on favoritism and other issues, it is to be based on merit. So until our institutions come into that level, so institutional arbitration will not grow. And that is the future. So for domestic arbitration will grow, but at the same time, recently I have seen and I have spoken to some of the CMDs of some PSUs. They say for high value arbitration, we don't trust arbitration. Now, again, this thing is to be addressed, and recently some of the PSUs have deleted the arbitration clause. But in long run, I think government has a focus for arbitration. Domestic arbitration will pick up here. International commercial arbitration, India becoming hub of arbitration, I think it is a long distant dream, and not we don't have the systems as on today here. Internationally, I will tell you that probably international commercial arbitration globally will grow. But in domestic cases, there are other things like statutory adjudications which have taken the load from arbitration. So focus has moved to those instead of domestic arbitration international. But overall, I will tell you it has a great future, and it will be there for time to come. Thank you.
Thank you so much, sir. We hope that this has widened the thinking process of the students.
Thank you.
Thank you so much, sir, for your illuminating views on these particular topic. And thank you so much, Sajal, for taking up the question answer round. Now, I would request Sanjeevni, another student of Bharati Vidyapeeth, deemed to be University, New Law College, Pune, and a student member of our cell, to kindly render the vote of thanks. Sanjeevni, please.
Good evening, everyone here. I, Sanjeevni Mishra, on behalf of Bharati Vidyapeeth, deemed to be University, and Madhyastada, the ADR cell of New Law College, Pune, have the honor and privilege of proposing the vote of thanks for this engrossing session. First of all, I would like to thank Mr. Ganesh Chandra Kabi for his valuable insights on the career perspective to students in the emerging field of construction arbitration. I'm sure students have a lot to partake from this session. My special thanks to Principal in Charge, Bharati Vidyapeeth, Team to be University, New Law College, Dr. Bhagyashree Deshpande, and our faculty coordinator, Ms. Shivangi Sinha, for her constant support and guidance. I would also like to thank our management team of Bharati Vidyapeeth, Team to be University, for their technical support. And at last but not the least, I would like to thank all our viewers for being such a lovely audience. We hope to see you all in the next session of our Prudentia Amicus. Thank you all for being there.
Thank you. Thank you so much, sir.
Thank you.
Thank you.